my name is Schyler Church. I am a California real estate broker as well as a member of the education department at Accredited Real Estate Schools. We offer the course requirements to be eligible to take the state exam in California to receive your real estate license, but also different levels of preparation to help you make sure you're prepared to pass that state test. And one of the tools we use is practice questions. And with practice questions, they are a good option to see how well you're doing with the material, how proficient you are in it, and also how good you are at applying it to the type of questions that you might see. And today we're going to be doing some practice questions, and we're going to go over just a few questions to hopefully give you an idea of how well you're doing on it and also reinforce the material. So let's get to it. Question number 1. A promissory note and deed of trust are given to a seller to finance the purchase of vacant land. The buyer will place a construction loan on the land. The deed of trust will most likely contain A, an alienation clause, B, a subordination clause, C, an acceleration clause, D, a due on sale clause. Well, we have to first figure out what the question's asking, what we know, and then to be able to then answer the question to the best of our ability, because there's always going to be some good answers. You just need to know which one's the best, most correct answer option. So let's figure it out. A promissory note and deed of trust are given to a seller to finance the purchase of vacant land. Well, this is just a fancy way of saying it is a seller carry. So the seller is going to be the lender in this case. So a buyer is able to purchase vacant land. So there's going to be a promissory note and deed of trust. Remember, the promissory note is just the evidence of the debt. It's the IOU, whereas the deed of trust is the security. So it's the collateral. So the property will actually be the collateral for that loan. And the seller is being the lender. And so the buyer will then purchase the vacant land. The seller will be the lender. So it's a seller carry with that promissory note and deed of trust. The buyer will then add a construction loan on the land. So this construction loan will be the buyer will get after the land has been purchased through a seller carryback loan. And they want to know what the deed of trust will most likely contain. And they're talking about the deed of trust actually with the seller carry loan. So we're actually talking about the one that is the given to the seller to finance the purchase of vacant land. We're talking about that deed of trust. What will that deed of trust most likely contain? Well, we have to think about what we know about deed of trust, what clauses are in those deed of trusts. Well, yes, we do have acceleration clauses, and within that, the alienation due on sale. Those are in deed of trusts. But in this particular question, what are they actually really wanting to know regarding the specifics of this question? So the best answer will be subordination clause, because the subordination clause, as you know, the construction loan is going to want the seller carry loan to have a subordination clause in it, so the construction loan can then take priority of the if they were to foreclose and have to recoup their money, then they would want to be first in right, or in first position, because as you know, the rule first to record is first in right. So on the seller carry loan, that would have been the first one to have been recorded. The construction loan would have been in the latter position. The construction loan does not want that. They want to be able to be in the first position, so they want to be able to switch with the seller carry. To do so, the seller carry deed of trust will most likely have a subordination clause. So the best answer is B, subordination clause. Yes, all of these are good answers because of what a deed of trust does contain, but the question is particularly asking, that's where you really need to know what the best answer is for the question, the most correct answer. And the most correct one for this particular question is a subordination clause. 2, the power of sale is given by the A, trustee to trustor, B, trustor to trustee, C, trustor to beneficiary, D, beneficiary to trustee. So what we need to know about on a deed of trust is the power of sale, what that is given for when a deed of trust is used, that an entity can then foreclose on the property, sell the property if the borrower defaults. So we just need to know what all these parties are called and how they're involved in a deed of trust. So the first party we have is the trustor. Remember, the trustor is the borrower. They're the ones borrowing the money. The beneficiary is the lender. So that is the lender. But then we have something called a trustee. And this is when a deed of trust, really what sets it apart from a mortgage as well, is because of the foreclosure process. The power of sale is given to the trustee. The trustee is just like an independent third party that has the ability to foreclose, sell the property if the borrower were to default. So the trustee has the ability to do so. They have bare naked legal title to be able to sell the property if the borrower defaults. So knowing all of these terms, we then have to know the power of sale is given by the who to who. Well, it's given to the trustee. So we know it's either going to be B or C. But is it given by the lender or the borrower? Remember, so in this particular thing, power of sale, because the bare naked legal title is given to the trustee to be able to sell the property, and so it's given by the borrower, who is also called the trustor. So the best answer is trustor to trustee. The power of sale is given by the trustor to trustee. So you really have to remember the terms to the parties of a deed of trust, and you need to know how a deed of trust works. 3. Under federal truth in lending, a 3-day right of rescission period would occur A, on a loan secured by a second trust deed for an owner-occupied single-family home where the money is borrowed subsequent to the purchase. B, on the purchase of an owner-occupied single-family home. C, on the purchase of any 1 to 4 unit owner-occupied property. D, all of the above. We're talking about the federal truth in lending and that 3-day right of rescission. Well, when you think of that 3-day right of rescission, you should be thinking of refinances. So if you refinance a property, you have a 3-day right of rescission under the federal truth in lending. So knowing that for a residential property for refinance, what is the best answer here? Well, it would be A, on a loan secured by a second trust deed for an owner-occupied single-family home where the money is borrowed subsequent to the purchase. Subsequent to the purchase. That is basically saying a refinance. So you need to know, be able to dissect what they're asking here and be able to figure out what they're saying. And so they're talking about refinances on a loan of a second trust deed for an owner-occupied single-family home. So that the 3-day right of rescission period would apply to that. It would not apply, though, to the purchase of an owner-occupied single-family home because that is the purchase money loan that is used. That does not have a 3-day right of rescission. It's not a refinance. C, on the purchase of any 1 to 4 unit owner-occupied property. No, because they're talking about the actual purchase of it. That is incorrect. So what we want to know about is it a refinance, and the best answer option is A. 4. When a person makes a payment on a loan, A, their equity goes down, B, their debt goes up, C, their equity goes up, D, none of the above. So the DRE for this particular question is asking, I should redo that. So the question is asking if a person is making a payment on a loan, what is happening to the debt or the equity? That's what they're basically asking here. So on a normal loan, it is going to be a fully amortized loan. And on a fully amortized loan, when you're making a payment, remember, you're paying interest and principal. So when you're paying that payment, you're making that payment, you're going to be paying at least some principal. Whether the amount of principal is higher or lower depends on the length of the loan, what time period you're at, so what payment number it is. And so that's going to really make a difference on it. But they're just saying on the general grand scheme of things, what will happen to either the debt or the equity? Well, if you're making a payment on the loan, you're going to be paying some principal. And so the principal will then decrease the loan amount that'll be due. So what is happening overall? Well, your debt is going to be going down. So we know B is not correct. Equity, as you remember, equity is the value of the home less any loans on it. So if you're decreasing the loan amount, you're then increasing your equity. So your equity goes up. That is the best answer because you are making payments. The loan balance that is due goes down. That will then increase the equity in your home. So remember, it's the value of your home less any loans on it. There's also other names or other ways to define equity, but that's the best way to think about it for this particular question. On a purchase money deed of trust, the trustor, A, loans the money, B, holds legal title to the property, C, signs the deed of trust, which is then used as security for the loan, D, all of the above. So we've already talked about the parties of when a deed of trust is used. So remember, the trustor is the borrower when a deed of trust is used. And on a purchase money loan, purchase money is when it's used to purchase a property. So the money is used to purchase a property. It's in the name. That deed of trust. So what does the trustor do on a purchase money deed of trust? Well, let's look at the answer options. A, loan the money? No, the beneficiary is the lender. So that would not be correct. B, holds legal title to the property. No, remember, when we've talked about a deed of trust, the bare naked legal title is given to the trustee. So the trustee is the one that has the ability to foreclose on the property, has the power of sale. So that would not be correct. C, signs the deed of trust, which is then used as security for the loan. Correct, because remember, the trustor is the borrower. They're the ones that is deciding when they're purchasing a property to get a loan, and they're using a deed of trust, which is the collateral, the security for the loan. And remember, the deed of trust goes hand in hand with the promissory note, and that is the IOU, the evidence of the debt. So the best answer is C, signs the deed of trust, which is then used as security for the loan. That is what the trustor would do on a purchase money deed of trust. 1. A real estate transfer disclosure statement need not be prepared for A, fourplex apartment property, B, 10-unit apartment complex, C, mobile home, D, condominium. Well, as always, I always tell students to make sure, let's decipher the question. Understand what the question is saying, what you believe the answer to be without even looking at the other answer options. So, real estate transfer disclosure statement. What do we know about it in California? Well, this became a requirement in 1987, and it is required for sellers to use and disclose material facts and answer pertinent questions for properties that are 1 to 4 unit residential homes. So knowing this, we automatically know that the fourplex apartment property, that does need to have a transfer disclosure statement. A 10-unit apartment complex, that is greater than 4 units. So that does not require a transfer disclosure statement. But let's make sure on the other ones before going with B. Well, mobile home, that is it's intended as a primary residence, even though it may be technically personal property, it does require a transfer disclosure statement, as well as a condominium. So all of these require transfer disclosure statements except B, 10-unit apartment complex. And let's go through the specifics a little bit of specifically what that TDS is. So the TDS applies when real property of 1 to 4 dwelling units is transferred by sale, exchange, installment, land sale contract, ground lease coupled with improvements, lease with an option to purchase, or any other option to purchase. So this is when a 1 to 4 unit property, residential property, needs to be, you have to use a TDS with it. And it also pertains to the resale of a manufactured home or a mobile home, even if classified as personal property, provided that the manufactured or mobile home is located on real property and is intended for use as a residence. So these are key elements of the transfer disclosure statement. But the biggest thing is when you think of the TDS, 1 to 4 unit residential property, and it needs to be used and provided for if it's a sale, an exchange, or even if it's a ground lease coupled with improvements, a lease with an option to purchase, or any type of option. And also mobile homes if it's used, mobile homes or manufactured homes if it's used as a residence. 2. On the real estate transfer disclosure statement form, the broker must A, inspect all common areas, B, inspect accessible areas and inaccessible areas and inform the buyer and the seller. C, inspect all areas, including inaccessible areas, and report his or her findings to the buyer. D, make a visual inspection of all accessible areas and report his or her findings on the form. Well, what do we know as a real estate agent when you are representing your principal on that TDS? Well, you need to inspect and do a visual inspection of all accessible areas. So if it's an inaccessible area, or for instance, common areas that aren't on the property, then you do not need to do a visual inspection of it. But it has to be all accessible areas, and your findings must be notated on the transfer disclosure statement. Needs to be notated on it. So even for instance, if your seller decides to refuse to fill out the transfer disclosure statement, even though they're required by law, first of all, you shouldn't be working that listing to begin with, but you need to, as the agent, fill out the visual inspection portion of it. And also remember, there's two portions of it. It's for the agent that representing the seller and the agent representing the buyer. They both do their own visual inspection. So as you can tell, the best answer is D. Make a visual inspection of all accessible areas and report his or her findings on the form. You do not need to inspect the common areas. You do need to inspect accessible areas, but you do not need to inspect inaccessible areas. And then inspect all areas. That word all is key there because it says including inaccessible areas and then report it on the form. Or report it to the buyer. And remember, this needs to be notified or notated on the form so the seller and buyer both acknowledge your findings. So visual inspection. So a little bit about it. So the listing and selling brokers or agents must each conduct a reasonably competent and diligent visual inspection of real property, which consists of 1 to 4 dwelling units that is sold through said brokers or agents. This also includes manufactured or mobile homes, because remember the difference is based on the year that they were built. But agents do not need to inspect areas that are not reasonably accessible, areas off the site of the property, public records or permits concerning the title or use of the property, or the common area if the property is in a common interest development if the seller and the seller's brokerage agents comply with the Civil Code Section 1368. So these are the specifics to that agent visual inspection, that portion of the requirement of the transfer disclosure statement. 3, intentional concealment by a real estate broker is considered A, negligent misrepresentation, B, legal under a fiduciary duty, C, breach of contract, D, fraud. So intentional concealment, you should automatically be thinking of misrepresentation. Now, what type of misrepresentation? Is it intentional or negligent? Well, it's in the question here. It's intentional concealment. So we know this is intentional misrepresentation, which is another nice way of saying fraud. The way of lying. Even though you didn't maybe specifically lie, you omitted something of relevance, of importance. And so that is still fraud. And to break down what misrepresentation is and the types. So misrepresentation occurs when a principal or agent conceals or falsifies the condition and or other material facts about a property. So we have two types of fraud, two types of misrepresentations. We have intentional misrepresentation and negligent misrepresentation. So intentional misrepresentation is fraud, and that falls under intentionally lying. So actual fraud and negative fraud. Actual fraud is when you say something, you do something that is specifically intentionally lying, fraudulent. Negative fraud, this is where you conceal information. You're omitting information that is relevant to the transaction for a material fact. And then negligent, this sometimes happen, it can be an honest mistake that causes a client harm. You didn't mean for it to happen. It was just something that you missed. So that is negligent misrepresentation. And that is usually covered under your errors and omissions insurance, but always there's exceptions to the case on the rule on everything it is. But you need to have this in mind. 4, a transfer disclosure statement is not required for A, bank foreclosure, B, single-family home sold by an agent, C, single-family home sold for sale by owner, D, fourplex. So as you can tell, we've talked a lot about this TDS. because it is vital for when you're practicing, but also you need to really know it for the state exam. That's why we have so many questions on it. So the transfer disclosure statement, as we know, it pertains to 1 to 4 unit dwellings. Well, when is it not needed though? So, okay, we know it's required for single family homes. Whether you're as an agent are representing the principal, it's the transfer disclosure statement the seller has to fill out, as well as the agent portion of it. But this is a requirement in the Civil Code. The transfer disclosure statement is mandated in the California Civil Code, and it's for the seller. The seller has the ultimate responsibility of completing the transfer disclosure statement. So even if it is a FSBO, for sale by owner, you need to, as the seller, complete the single family home. If it's a single family home, you need to complete the TDS. Even if there's no agents involved. The good news is, if there's no agents involved, the agent portion of it does not need to be filled out. But the seller has the ultimate responsibility of completing this transfer disclosure statement. And it is required for a fourplex. Remember, 1 to 4 unit dwellings. So a fourplex would be considered within that. So B, C, and D, we know do require the transfer disclosure statement. So just from the process of elimination, bank foreclosure would be the right answer. But why is bank foreclosure the correct answer? Well, there are some exemptions to this. So the following transfers are exempt from the TDS requirements. So one of them, foreclosure sales, whether it is a non-judicial or a judicial foreclosure, those are exempt from requiring the TDS. Most of the time it's because the bank owns the property and they don't really know anything about it anyways because they had just gotten it and now they're going to try to, as we call, dispose of the property by selling it to someone else. So they usually don't know much, so they're exempt from it. Also, new home sales, if they're part of a subdivision project where a public report is available and must be delivered, then the TDS is not required. But if you are a real estate broker and you're selling or representing someone that is purchasing a new home, you still owe the buyer a duty to disclose any material facts which affect the value, desirability, and intended use of the property. Court-ordered transfers, those are exempt. Transfers by a fiduciary and the administration of a decedent's estate, a guardianship, conservatorship, or trust, except for the trustee is a former owner of the property. So there's a lot to this, but the key ones you really need to know for the state exam are the new home ones when there's a public report, foreclosure sales, but also trusts, except if the trustee is a former owner of the property. Also transfers to a spouse or to a person or persons in the lineal line. Transfers resulting from a judgment of dissolution of marriage or of legal separation, or from a property settlement agreement incidental to such a judgment. Transfers from one co-owner to another. Transfers by the state controller for unclaimed property. Transfers resulting from failure to pay taxes, and transfers to or from any governmental entity. So as you can tell, there are quite a bit of exemptions, but the ones you need to know about are the new homes, when the public report is available, foreclosures, and trusts. If the transfer is by a trust, except if the trustee is a former owner. Those are the big ones you really need to know for the state exam. But here's the list of it. Make sure to review this though. 5. The following practice is illegal. A, keep the seller's secret that he or she is getting a divorce. B, refuse to disclose the religion of the seller. C, keep the seller's secret that the roof leaks. D, refuse to disclose the race of a prospect. So automatically, there are obvious fair housing issues here. So you should refuse to disclose the religion of the seller or the race of the prospect. That is fair housing issues, and you are not allowed to do that. So if you disclose the religion of the seller or disclose the religion of a prospect, then it'd be illegal. But refusing to do so, that is not illegal. And keeping the seller's secret that he or she is getting divorced, that is not a material fact to the transaction. So that is not illegal to keep that information privy as part of your fiduciary duty. That is not a material fact to the transaction. Now, so the best answer automatically, based on the process of elimination, is C, keep the seller's secret that the roof leaks. Well, that is a material fact, and you must disclose it because remember, as an agent, you are have a duty of honest and fair dealing to the other third parties in the transaction, as well as disclosure of material facts. And a leaky roof is a material fact that must be disclosed. So that is very important, and it would be illegal for you to not disclose a leaky roof. Also, a big one that shows up on the state exam is extensive plumbing repairs. That's a big one as well. Those are important to know about as they are the commonly used material facts that must be disclosed for state exam purposes. One, if a contract has been executed, it means that A, both parties have performed completely their obligations as provided by the contract. B, matters relating to the contract remain to be performed. C, only one party must perform. D, none of the above are correct. Okay, so we're talking about an executed contract, not an executory contract, because executory means that it's in progress of being performed. So looking at this, the best answer is A. Both parties have performed completely their obligations as provided by the contract. That means that they have performed them, they've executed them, and the contract has been done and completed by the parties. Whereas B is they're talking about an executory contract. And C, only one party must perform. No, that's not true. When it's been executed, it means that all parties have performed their obligations stipulated by the contract. And D, none of the above are correct. Well, that would be the correct answer if A wasn't an option. So, 2, all of the following are necessary elements of a contract, except A, writing, B, legal objective, C, consideration, D, competent parties. Well, we're talking about a contract, any type of contract, not necessarily just a real estate contract. Well, we know there are 4 elements that are always needing to be completed for a valid contract, which is legal objective, consideration, mutuality, and competent parties. Those are necessary elements. And then writing is a requirement when it comes to the statute of frauds. So if it's a real estate contract, all real estate contracts must be in writing except leases of a year or less. And then when it comes to any type of contract, the statute of frauds also applies. If it takes over a year to perform, then the contract must be in writing. But always necessary elements of any contract are all of them except writing. And we'll go through this. Remember, for a valid contract, there's 4 essential elements of any valid contract. Competent parties, so the capacity to contract, so not have been declared incompetent in a court of law, or minors, for instance, unless the minor has been divorced, is married, in the military, or emancipated. Mutual consent or mutual assent, that just means mutuality, that there's genuine offer and genuine acceptance. 3, that there's a lawful objective. If it was to obtain, for instance, drugs, an illegal type of drug, well, that's not a valid contract because its purpose is not lawful. It's not legal. 4, sufficient consideration. Remember, so anything of value, it has to be sufficient. It can be a service, act of forbearance, could be money, could be an asset. Does not need to be cash, though. And then one more for real estate contracts. Due to the statute of frauds, it must be in writing except for leases of a year or less. So with the other question, all of them are valid for a valid contract, except writing, unless it was a real estate contract. But remember, leases of a year or less do not need to be in writing. 3, a single man sells real property that he owns. After the contract is signed, escrow has closed, and the deed is recorded. The title company discovers that the man is under 18 years of age. The transaction is A, voidable, B, void, C, valid, D, legal. So for state exam purposes, what we're looking at here is that there is a lack of capacity to contract because the man is a minor. If he was married, divorced, emancipated, or in the military, then it wouldn't matter that he's under 18 years of age. But that is not stipulated. So we have to assume he does not have the capacity to contract. Due to that, for state exam purposes, the correct answer is void. There's no legally binding effect because one of the necessary elements of the capacity to contract has not been met. So void is the correct and the best answer for the state exam. 4. A seller promises to pay a commission if the broker finds a buyer, and the broker promises to use diligence in finding the buyer. This is called A, unilateral executed contract, B, bilateral executory contract, C, unilateral executory contract, D, bilateral executed contract. Okay, so what we're looking here is that we have to figure out if it's bilateral or unilateral, and if it's executed or executory. So we're looking at here. So the seller promises to pay a commission if the broker finds a buyer. So the seller's promising something. And the broker promises to use diligence in finding the buyer. Well, the broker's also promising something. So it's a promise for a promise. Okay? So if we know promise for a promise, we should automatically be assuming bilateral contract. If it was a promise for an act, that is a unilateral contract, but bilateral is correct. And now, is this executed or executory? Well, let's see here. Is the contract been executed yet? Has it been completed by all parties? Or is it in the progress? Is it being in progress of being completed? That would mean, is it executory then at that point? Well, knowing all of this, the correct answer is a bilateral executory contract because the contract has not been fulfilled by all parties yet. It's in progress. So bilateral executory contract. 5. Novation is most closely related to A, realization of an unexpected profit, B, creation of an existing agreement, C, substitution of a new contract for an old one, D, modification of a contract. Okay, so we have to think here, what does novation mean? Novation is substituting something old with something new. So it's basically getting rid of the old one for something new. Well, when it comes to contracts, the best answer here then is C, substitution of a new contract for an old one. We're not talking about realization of an unexpected profit. That's not something. Creation of an existing agreement. No, that's just basically replicating an agreement. And then D, modification of a contract. No, we're not. Well, we are doing a kind of a modification, but it's a substitution where we're completely getting rid of the old contract with a new one. So that's novation. And so we're substituting. So the best answer is C, substitution of a new contract for an old one. 1. An agency relationship is best established by A, implied contract by law, B, voluntary by agents, C, written contract, D, oral agreement. Well, automatically you should know any agreement, not just for agency, but any agreement should always be in writing. That is your best bet. Also because the statute of frauds, on a lot of times it needs to be in writing, but an agency agreement, that is best done as an express contract, but more specifically in writing. So it should be written contract. That is the best way to establish an agency relationship, and it's the best way to have any type of agreement. So written contract. 2. The buyer's agent should disclose his or her relationship to other persons involved in a sales transaction. A, before escrow closes, B, 30 days before escrow closes, C, as soon as possible, D, none of the above. Well, you should automatically be thinking of agency disclosure, and when that needs to be done, well, it needs to be done as soon as possible or as soon as practicable. It needs to be done ASAP. Everybody needs to know who's representing who within a transaction within a very timely manner. It's not set by law of how soon it needs to be done. So as soon as possible is the correct answer. You might be thinking, well, that's kind of a little vague. Maybe it's none of the above. This is where it's a simple question, but it could be relatively tricky. So you do need to know for this particular purpose, it is as soon as possible. And remember, agency disclosure is 3 steps. You disclose, you elect, and you confirm. So make sure to keep that in mind, and that needs to be done as soon as possible. 3. A position of trust assumed by the broker as an agent for a principal is described most accurately as an employment relationship, B, fiduciary relationship, C, trustor relationship, D, gratuitous relationship. This is a relatively easy question if you've been studying agency. When you think of agency and the relationship you have as a real estate agent with your principal, you should automatically be thinking of fiduciary relationship. Because, as I say, when you're looking at questions, before even reading the answer options, understand what the question's asking and formulate your own thought process of what the answer is without even knowing what answer options are provided. So when you're talking about agency relationship that you have with your principal and in regards to a position of trust, you should automatically be assuming or thinking of fiduciary relationship. And that is an answer option here. And clearly the other options are not correct answers. An employment relationship, no, that's not something we have with our principal. Trustor relationship, a trustor, remember, deals with the deed of trust and is the borrower. Gratuitous relationship, there is a thing called a gratuitous agent, but that's not what we're talking about here. So the best answer is fiduciary relationship. And let's go through this again. So the little diagram that we have for an agency relationship. So when we are the agent and representing our principal, so on either side, let's say we're the listing agent representing our seller, well, we have an agency relationship to the seller and we have a fiduciary duty to the seller. If we are the selling agent, we then have a fiduciary duty to the buyer. That is the principal that we directly have an agency relationship with. Now, if we are a listing agent, and then what type of relationship do we have to other third parties? So for instance, like the buyer, well, we have a duty of honest and fair dealing. It's less than a fiduciary duty, but it is something where we have to be honest and fair to other third parties. And also we have the requirement to disclose all material facts. So keep this diagram in mind. This will help you a lot with the agency section. Question number 4. According to the law of agency in the Civil Code, the fiduciary duty of the agent for the buyer is A, being a sub-agent, B, telling the buyer which escrow company to use, C, giving the buyer advice about how to hold title, D, acting with the utmost care, integrity, loyalty, and honesty on behalf of the buyer. Well, let's see here. We're talking about agency and specifically a fiduciary duty of the agent to the buyer. So of the agent for the buyer. So, well, when we're talking about here, we know automatically we cannot tell anybody who to use escrow. We can give recommendations and referrals, but we cannot force any of our principals to use a specific escrow company or title company, etc. And we also cannot give advice about how to hold title, how title should be vested. We are not allowed to give tax, legal advice, and we're not allowed to give advice regarding holding title. That is beyond our scope of duty and our knowledge base. So being a sub-agent, that is something that deals with agency, but not in regards to the question for the best answer, because we're talking about fiduciary duty. And a fiduciary duty is one that we act with the utmost care, integrity, loyalty, and honesty on behalf of the buyer. Thus, the correct answer is D, acting with the utmost care, integrity, loyalty, and honesty on behalf of the buyer. Question number 5. The broker, as agent of the seller, owes the buyer A, only a duty to disclose any item which relates directly to the sales price of the property, B, the same fiduciary obligations he owes to the seller, C, only the duty to answer questions honestly, D, the duty of honest and fair dealing. So the broker is agent of the seller. So if he is the listing agent or she, well, what do they owe the third party in the transaction, which is the buyer in this case? Well, you should be thinking of that diagram we had just shown and talked about. Remember, they owe a duty of honest and fair dealing to the third parties in the transaction, which is the buyer in this case. So the best answer is D, the duty of honest and fair dealing. As well, though, as the duty to disclose all material facts about a property. So basically, only a duty to disclose any item which relates directly to the sales price of the property. No, that's not the only duty that the agent has. And the agent does not have the same fiduciary duty obligations to the buyer as he does to the seller. He only has fiduciary obligations to the seller. Only the duty to answer questions honestly. Well, he does have the duty of being honest, but also of being fair, disclosing material facts. So there's more to it. So only is the big keyword too between them in those answer options. So again, remember, here is this agency relationship diagram that we have between the agent and the principal, the fiduciary duty they would have, and then the duty of honest and fair dealing to the other third parties. Number 1, the U.S. Fair Housing Act was passed in A, 1959, B, 1968, C, 1977, D, 1987. This is the main federal fair housing law that we're actually talking about. So the U.S. Fair Housing Act. There was one that we had, the first federal fair housing law, which was the Civil Rights Act of 1866. That was largely ignored for about 100 years. And that's when the Civil Rights Act of 1968, which we call the U.S. Fair Housing Act, was implemented. And so the correct answer is 1968. And you need to make sure you have this one because this became the main federal fair housing law. It prohibits discrimination in the sale, rental, advertising, offer of brokerage services, loans, or appraisal services based on a person's race, color, religion, sex, marital status, national origin, or handicap. Okay, so 1968, this is the main one. The first one was the one from 1866, but the main one is 1968, and that is what we refer to as the U.S. Fair Housing Act. And this was the first year the Supreme Court prohibited all racial discrimination when real property is sold or rented, and the U.S. Fair Housing Act was from Title VIII of the Federal Civil Rights Act. A person applying for a new loan is asked by the loan broker to fill out a questionnaire. The form requests the applicant's race and marital status. The applicant can A, supply the information requested so the applicant's credit history can be properly checked. B, file a complaint with the real estate commissioner. C, refuse to disclose the applicant's race or marital status. D, the applicant may do any or all of the above. Okay, so what do we know about this? Well, it's illegal for the loan broker to be asking for an applicant's race or marital status. That's something that they cannot use to make decisions. Due to that, we know that the applicant can refuse to disclose that information. That is completely legal. And the applicant can also file a complaint on the federal level, with HUD, the Department of Housing and Urban Development. That is where you would issue complaints regarding discrimination. So knowing all of this, what would be the correct answer? Well, it looks like C would be the right answer. And why? Well, because A, you do have the ability as an applicant to supply that information requested, but it's not so they can use it for a credit history that will be properly checked. That's not the case. So that's not correct. And then filing a complaint with the real estate commissioner. The commissioner in California deals with issuing and revoking real estate licenses. They do not deal with fair housing. That's on a federal level, and you would want to talk with HUD. But you do have the ability as an applicant to refuse to disclose and leave those items blank, your race or marital status, or both, for instance. So the correct answer would be C. 3. A real estate broker undertakes to canvass a neighborhood area that is very near to a section into which minorities have recently moved. He tells the people to whom he talks that they should sell now, as their property might suffer a loss in value in the future. This is illegal and unethical, and the broker is guilty of A, blockbusting and panic peddling, B, steering and redlining, C, property conduct, D, none of the above are correct. Well, ultimately what we're getting here is saying that a broker is telling people their property is going to lose value because minorities are moving in. Completely illegal. And that due to this, we know it's illegal and unethical. But what is the broker specifically guilty of? Well, he's trying to induce someone to sell because of this, so block busting and panic peddling. 4, the agency that would receive complaints concerning fair housing laws is A, Department of Community Development, B, Department of Real Estate, C, Department of Fair Employment and Housing, D, none of the above are correct. So actually what we're talking about here is the agency. Which one would we be talking? Well, this is actually on a state level, and normally on a federal level, we would go to HUD. Well, when we're talking about complaints, they would receive complaints concerning fair housing. Well, we know the DRE does not deal with fair housing, as well as the Department of Community Development. But the Department of Fair Employment and Housing, they do deal with fair housing laws. And so they would receive complaints concerning fair housing in the state of California. And 5, the Holden Act refers to A, discrimination in the sale and rental of housing accommodations in California, B, discrimination in business establishments, C, discrimination in federal fair housing laws, D, discrimination in loan practices, including redlining. Okay, so when we're talking about federal or fair housing laws, because remember, these are state-specific in California fair housing. Well, Holden deals with discrimination, but it deals with it in lending. Because remember, Unruh deals with businesses, and the Rumford Act deals with discrimination in the sale and rent of residential properties. So due to this, the best answer would be D, discrimination and loan practices, including redlining. That is what the Holden Act is referring to. And to talk a little bit more about redlining, so remember, redlining is illegal. This is when, so the Housing Financial Discrimination Act of 1977, which is called the Holden Act, it refers to discrimination in lending practices. The Holden Act helps to stop a process called redlining. And this is when lenders drew a red line around areas where they would not make loans. The lack of loans in these areas caused the areas to become blighted and compounded the problem. The Holden Act made redlining illegal. So basically, whereas you can see here, they would basically say, hey, this is a bad area, we're not making loans and if it falls within this line, these red lines. That's completely illegal and not allowed. And the Holden Act made it illegal. Thanks for watching. I hope this video was helpful in your licensing journey and your studies. If you liked it, make sure to give us a big thumbs up as well as subscribe to our YouTube channel so we keep producing new content. But if you have any questions or if you'd like to check us out for completing coursework to be eligible to take the state exam or even for preparation to help you prepare for the state test, we have tons of options and I have our website listed below. Otherwise, I'm Schyler with Accredited Real Estate Schools, and thanks for watching.